Okay. You ready? Okay. Jefferson County Code Law number 2 is now in session. The court is in session and calls number M331246. Case is style of state of Texas versus Dallas Clavell Jr. Let the record reflect that Mr. Clavell is present in court with his attorney, Attorney Jennifer DeLage. Let the record also reflect that the state is present with Assistant Criminal District Attorney, Attorney Cornelius Williams, Attorney Fred Vernon, and Attorney Farrah Nixon.
Good morning, Your Honor.
Good morning. State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
Defense is ready, Your Honor.
Okay. Okay, y'all may be seated. You can bring the jury in. Everyone, please stand as the jury comes into the courtroom.
They need to all come at the same time.
Okay, just y'all can be seated. Okay, that's fine.
Walk in.
Okay, everyone, please rise. Okay, you may be seated. State, are you ready?
State's ready, Your Honor. Good morning.
Defense, are you ready?
Defense is ready, Your Honor.
Okay, you may be seated. Let the record reflect that the jury is now seated and present in the courtroom. Let the record also reflect that Mr. Lavelle is present in the courtroom with his attorney, Attorney Jennifer DeLage. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Fred Vernon, Attorney Cornelius Williams, and Attorney Farrah Nixon. At this time, ladies and gentlemen of the jury, I will now read to you the court's charge. Members of the jury, the defendant, Dallas Clavell Jr., stands charged by information with the offense of theft alleged to have been committed on or about the 7th day of September of 2021 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our law provides that a person commits the offense of theft if he unlawfully appropriates property with intent to deprive the owner of such property, so that you may better understand the nature of the offense with which the defendant is charged. I now define certain terms and words. Appropriate, as used herein, means to exercise control over personal property. Appropriation of property is lawful if it is without the owner's effective consent. Deprive, as used herein, means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means consent in fact, whether expressed or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Possession means actual care, custody, control, or management of the property. Property, as used herein, means tangible personal property or documents, including money that represents or embodies anything of value. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to cause the result and had knowledge that the prohibited result will occur. You are instructed that if there is any testimony before you, in this case regarding the defendants having committed offenses other than the offense alleged against this information in this charge, you cannot consider said testimony for purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense, if any were committed, and even then you may only consider the same as evidence that the defendant misrepresented himself and to gauge the defendant's credibility, not as any proof that he is guilty of the charged offense and for no other purpose. Now, if you find from the evidence beyond a reasonable doubt that on or about the 7th day of September 2021 in Jefferson County, Texas, the defendant Dallas Clavell Jr. did then and there unlawfully appropriate property by acquiring, exercising control of corporal personal property, namely money orders owned by Gloria Parker, hereafter style of complainant, of the value of at least $100, but less than $750, with the intent to deprive the complainant of the property and without the effective consent of the complainant, then you will find the defendant guilty of theft as charged in the information, unless you so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant's guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberations, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiffs upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make sure that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to this charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page that is attached to this charge is the verdict page. And it looks like this. It has two parts. It has a top and a bottom. The top portion states, we the jury find the defendant not guilty as charged in the information of theft. If that is your verdict, then your foreperson will sign on the top line. And it says, or at the bottom, we the jury find the defendant guilty as charged in the information of theft. And if that is your verdict, your foreperson will sign on the bottom line. Does everyone understand? Okay. State, are you ready?
State's ready, Your Honor.
And defense, are you ready?
Defense ready, Your Honor.
Okay. Mr. Williams, you may go forward and you have 25 minutes. I'll be keeping time.
Thank you, Your Honor.
You're welcome.
Justice is a divine concept given to us in the form of law so we can all get along. When we began our journey back on Monday of this week, we discussed while justice is a high concept, everything that we need to get along with one another, we learned in kindergarten. We don't hit each other. We say please, we say thank you. When we're wrong, we say we're sorry. And we don't take other people's things. I submit to you that when we began this trial, and from the evidence in which we heard, one salient point permeates throughout. We can do better. We must do better. We must do better individually. We must do better as a community. And let me go on to say this right now, and just on the record. We welcome Farrah Nixon back, and we thank Fred Vernon for being able to step up and to assist in this matter. Now, let me say this. It's not the state's position at all that Mr. Dallas Clavell, who sits before you, who the state believes is proven beyond a reasonable doubt, we're not saying he's a bad man, but what we are saying, he did a bad thing back in September of 2021. The bad thing that he did was that he took 6 money orders. How do we know he took 6 money orders? Because, and you've seen evidence within this case, on State Exhibit number 1, the video, the store surveillance system, we know that 6 money orders were purchased at 1556 hours. Those 6 money orders, which were purchased, went to Mrs. Parker. How do we know that? Ms. Parker took the stand, she testified, and she told you. But not only that, we have further corroboration because of whom we heard from. Who was the first person you heard from? And throughout this, ask yourself, well, who do we believe? What makes more sense? Well, the first person we heard from was Mrs. Terry Angel. Now, ladies and gentlemen, she was presented so that the store videos could be admitted. The store videos were kept in the normal course of their business, that they were also operational at the time, and they captured the events. In fact, what is shown on the log of the money orders correspond to the time in which Mrs. Parker was in line. Now, the money orders which were purchased, being mindful, 6 were taken, but 2 money orders were cashed. Who were they cashed by? The person who took them, Dallas Clavell. The second person that the state called And throughout this, we asked ourselves, who do we believe? The second person who was called was indeed Mrs. Parker. Now, Mrs. Parker, you judge her credibility, you judge the facts, you weigh her testimony. As we keep asking, who do we believe? Now, between 1456 and I submit to you, 1506, between 256 and 306, back on September 7th, she told you, and once again, it corresponds with the documentation which is presented. We see her at the window on the right. At this time, she purchases the money orders. Then what does she do? She goes over to the window to the left. You guys remember the testimony. What does she do at the window to the left? She pays bills. She paid her electric bill. And who was behind her, who then paid his electric bill? Dallas Clavell Jr. Ladies and gentlemen, that is corroboration. Now, I want you to juxtapose the testimony of Mr. Clavell with that of Mrs. Parker. We knew that it wasn't because identity is an issue that the state must prove beyond a reasonable doubt, and we submit that it was proven beyond a reasonable doubt through the documentation. She said, being Mrs. Parker, I knew like the person I recognized the person who was in the orange. We know that there were 3 Dallas Clavells in Port Arthur. One was born in 1947. At first, Mr. Clavell said, I don't know if that's my dad. Then, upon further question, he admitted that that was not his dad on Stacy Exhibit number 1 on the video, who was behind Mrs. Parker. Second time, who is that your brother? Is that Dallas Dwayne Clavell? After question, he admitted it wasn't him. See, 2 out of 3 is gone. But only 1 Dallas Clavell. I submit to you, it's the same Dallas Clavell Jr., who was standing behind her, who paid the energy bill. That, ladies and gentlemen, is corroboration. The reason why we called next was Detective Richard Chase Paz. Now, there are things that can be admitted and not be admitted, but the state will submit to you. His testimony showed what? That back in September of 2021, she also identified the person in orange as a person who I know his daddy, I know his aunt, but he looks different today, 4.5 years later. He also took a statement from her. He took a written statement and a video statement. You would not get that because the rules of evidence would prevent that. You don't get police officers report, but you know what? The statement from the stand by Mrs. Parker is what was contained. You will not get that. We next called Mrs. Tracy Meir. Mrs. Tracy Meir was called as an executive for Market Basket over there, Ruth's Market Basket in the Groves, because she is the custodian of records and she's familiar with how those records are made. That is what is involved in State Exhibit number 7. She was able to pull those records. She was able to pull the records of the money orders which were purchased. That's why the state called her. That's how we're able to get the evidence is before you, which keeps pointing to one individual, the man who sits before you, Dallas Clavell. We next called Detective Marshall Christopher. Now, he is the embodiment of what the police did. You heard of his investigation. He said that he identified a Dallas Clavell based upon information which he had gathered, based upon the information which the other police had gathered, based upon the information that he got from Mrs. Parker. He began an exhaustive search. He matched the name Dallas Clavell. He matched his date of birth, January 1st of 1966. He also matched the bill, that energy bill. It all tied back to one person because he narrowed the scope. He narrowed that scope and it pointed to the person who sits before you now, Dallas Clavell. And his defense, Mr. Clavell took the stand. Now, ladies and gentlemen, you observe and you weigh the credibility of each and every witness. How did he testify? Is he believable? Do you believe Mr. Dallas Clavell opposed to Mrs. Parker, the records Mrs. Angel, the records Mrs. Meir, the information by Mr. Detective Marshall Robin? He sat there on that stand. He looked at you and he told you, "What me?" Okay. For example, what me? Okay. From able direct examination by counsel for defense. But upon cross-examination, remember, defense counsel, placed before you his surety bond and saying, compare that to the handwriting on the money orders. How do we know that it's him? She went through great pains. You don't see a loop here. You don't see a line there. I submit to you, ladies and gentlemen of the jury, beyond common experiences, common sense, how many times we can write our name and how many times would it look exactly alike? That's why the state had him to write his name 7 times. Now, I want you to think in your common experience, when you sign a check, how long does it take for you to sign the check? When you sign your name to any document, how long does it take for you to sign? When Mr. Clavell, Dallas Clavell Jr., whose names appeared on that bill, who was immediately paid after Mr. Parker, when he sat here and he began to write, you saw how long it took him to write his name. I submit to you that all the exhibits in which the name of Mr. Dallas Clavell appears, they are very similar. No expert testimony, don't need it, because you can use your common experiences. Now, he admitted on direct examination by the defense counsel, this is his name. This is how he signed it. I submit to you, when he sat before you within this court and he signed his name, you know what? They all look different, but they all look very similar. You match them up, you can compare. There was no one else behind Mrs. Parker. The man in the white shirt, the man in the blue pants, did he ever go there to the window? No, he did not. Only Mr. Clavell was behind her. Now, once again, the offense of theft. We have shown that a person appropriated property or took the property of another. Number one, we don't take things that don't belong to us. Who took those money orders? Mr. Dallas Clavell. Was it unlawful? Of course it was unlawful. Once again, it seemed like a kind of a crazy question. Did you give permission for him to take it? No, I did not. You see, because that's a consent element. She did not consent for him taking any of her property. How do we know that he had the intent to deprive her? Now, I want you to remember, between the time of 1456 and 1506, during a 10-minute period. Remember when he approached her behind, right? He was the next person at the counter. Submit to you, once again cooperated by the second energy bill. You see him there for a while, then he leaves. He leaves while Mrs. Parker came back to that right window. Why? Because she can't find her money orders, which she had purchased after paying that bill. So she comes back. What did Dallas Clavell do? He kept walking, ladies and gentlemen. Walk right past him. Then he stopped and say, "Oh, by the way, ma'am, I'm sorry. Here it is. Here are your money orders. Maybe you left them." No. That is intent to deprive the owner of the property. And how do we know this came full circle? Because those money orders were cashed, those two. The other four weren't. I submit to you, and you can infer those other four weren't because they were canceled. When asked the question, can you explain to the members of the jury how's that person in orange who's not your daddy, who's not your brother? There's only three. It has to be you. I don't know. I don't remember. How did those money orders with your name on it, corresponding with that electric bill, how they come into your possession? Explain it to the members of the jury. Oh, no, I can't. I submit to you that is beyond a reasonable doubt because he took those 6 money orders and the amount in which that he took, which he signed his name on, right there, over $400. 130 something and some change. Now, y'all remember when we began our journey, this started off again as a simple theft, but you know what you guys have experienced, what you members of the panel have experienced, this is the nature of a financial crime. How do you prove up financial crimes? You prove up financial crimes or the thefts through documentation, through testimony, that is circumstantial. And remember, circumstantial evidence and direct evidence is the same. We've excluded every other Dallas and jail out of Port Arthur. As stated, we have the burden of proof, and I submit to you, we met that burden of proof beyond a reasonable doubt. Each and every element, not beyond, of course, what, all doubt. Maybe an alien with the name of Dallas Clavell came down, went to Port Arthur, put on the skin of a man and not. That's not reasonable, ladies and gentlemen. I will not stand here and insult your intelligence. While the state does not have to, while the defendant did not have to prove anything, he did take the stand. And I submit to you what he told you and the explanations that he was not able to give. But also the explanation, it wasn't me. That's bananas. And this is not this is not that difficult, I submit to you. Although from the amount of time that we've taken on this trial, it is serious. It is simple, but it is difficult. And what is difficult is how you weigh the evidence and how you assess once again the guilt of this man. You, the members of the jury, you weigh the testimony. What is believable, what's not believable, what makes sense and what does not make sense. I submit to you from what the state presented to you through the evidence and through the testimony of the stand, through the exhibits admitted, prove beyond a reasonable doubt that Dallas Clavell took those money orders. Now, if you find something may be missing, maybe I don't know, I submit to you that once we get down to the heart of the matter, if there's a piece missing, if there's two missing, beyond a reasonable doubt, the state has proven the heart of this matter is that back in September of 2021, Dallas Clavell, man in the orange shirt, not the daddy, not the brother, stood behind her, took those money orders, wrote his name as the payor, name as the payee, endorsed that check. You can look at it. Beyond a reasonable doubt. We can do better. We must do better. And back then, in September of 2021, Dallas Clavell could have and should have done better.
Okay. It took 17 minutes, 30 seconds. Okay.
Good morning, ladies and gentlemen, the jury. Thank y'all all for being here. I know it's been a long week, a little longer than we expected, so we appreciate your time. I'm gonna start with the state has the burden of proving every single element beyond a reasonable doubt. We have talked about that throughout this case. It's not a guess. It's not, it seems likely. It is beyond any reasonable doubt in your mind, each and every element. Here they failed to meet the burden in two different ways. One, they have not proven who committed the theft. We'll talk about that in a minute. Also, they have not proven that if an actual theft actually occurred, because let's remember, we saw some confusion up at the desk, up at the courtesy booth, in Miss Parker's purse. We actually watched her lose an exhibit while we were sitting here in the courtroom. There's a little bit of confusion about what happened there. But if a theft occurred, it surely wasn't done with criminal intent, and they failed to prove that element beyond a reasonable. Now, as far as the identity goes, we have heard testimony that there were at least 3 Dallas Clavells in Port Arthur. We never heard there was exactly 3. We heard there were. The marshal sat here and said that. He also said he didn't find out about them until way later in his investigation. So at first, whenever he identified Mr. Clavell, that was prior to even finding out that there were more Mr. Clavells in the city of Port Arthur. Now, Bruce's Market Basket's in Groves. Did you hear any testimony about how many Dallas Clavells there are in Groves? Because there could be more. The video evidence and my client's testimony. I think we can all gather that my client was confused by some of those questions that the prosecutor submitted. I think he was confused about whether he was identifying someone or should identify someone as someone else. And again, this video evidence is 4.5 years old. Also, Miss Parker very clearly stated originally, and even when she was here, that the person she saw had clean shaven face and a clean head. Now, I understand it's 4.5 years later and my client does not have a clean shaven face and he does not have a clean shaven head. But we also heard that the photos that were submitted by the marshal of his Facebook and other photos of that time were all from 2021, the time that this incident occurred. So those photos give you a real life example of what this Mr. Clavell looked like in 2021. And those photos show a man with a scruffy beard and hair on his head. So his photos that were submitted are a completely different look than what Miss Parker said that person behind her looked like. She also did mention that her uncle's, grandma's, aunt's, cousin, friend knew of Mr. Parker. And after talking with them, it could have been, knew of Mr. Clavel, excuse me. After talking with him, it could have been Mr. Clavel, this Mr. Clavel. Again, that's one hearsay, no direct evidence, and it also, when sitting here, she could not identify this person as the person in line behind her that day. Next. There was another gentleman in line behind her. The gentleman in line behind her, other than the man in orange, was the man behind her at the money order booth. Again, let's remember, there were two booths. The booth to the right was the money order booth. The booth to the left was where you pay your bills. Miss Parker went over to the booth to the right. She got her money orders. She did a lot of things in that purse. She was holding some stuff went in the purse. Then she comes over to the bill area. As soon as she steps at the bill paying counter, the man behind her at the money order counter walks up to the counter. We have no testimony, no accounts of what happened with him at that counter, okay? She comes over here to the bill payer counter, and she's got a whole lot more documentation going on. And that's where the man in orange was standing behind her. So there was another man standing there behind the money order. Now, no witness testified that they saw the defendant take the money. Not a single one. Of all those 5 that were listed there, and here's the defendant, not one testified that they saw this defendant take the money orders. Not one of those 5 witnesses testified that they saw this defendant sign the money orders. There are 2 people that were not brought in as witnesses that could have really been critical in telling us what they saw that day. That would have been the person who worked the courtesy booth at Market Basket. Where were they? Where's their testimony? How about the person at the place where the money order was cashed? Where were they? Where's the video from the place where the money order was cashed? Speaking of, where was the place the money order was cashed? Did that ever come into evidence? Did not. There's no clear video. We've seen that video. It is blurry. It doesn't tell us anything. It tells us about positioning of 4 characters, but it doesn't exactly show us who they were or what they did. There's no fingerprinting. That's a tool for detectives. There's no fingerprinting. There's not a confession. My client has adamantly stated that he's innocent of this and there's nothing that firmly places my client as the person who committed this act. It's not. The state offered you assumptions and inferences, but our justice system does not allow convictions to be based on guesswork. When identity is uncertain, the law requires only one result. It requires not guilty. Quite simply, you did see a lot of talk about signatures. The signatures don't match. And if the signatures aren't a match, then they're not a fit. This is for y'all. I know you've all heard the quote. The glove doesn't fit, must it quit? If the signatures don't match, how can you find him guilty? You can't. Even if you believe my client was present, and of course, we don't believe the evidence shows that, you still got to find it intended to pay the money orders. That's not optional. It's an essential element to this. Where's the proof? Was there any witness statements about his intent? Did anybody talk about what my client intended that day? Nope. Was there any actions that my client made that clearly showed a plan to steal money orders? No. Intent is not something that can be presumed. It cannot be filled in by speculation. It's something that the state absolutely has to prove beyond a reasonable doubt, and they simply do not. This brings us to reasonable doubt. If you're left wondering any of these things, was it really this defendant? Do we know what he intended? Could there be another explanation for Dumpling from the beginning? Could there be another explanation? Those aren't small questions. Those are reasonable doubts. If you're thinking anything along those lines, that's reasonable doubt. Under our laws, reasonable doubt requires a verdict of not guilty. The state's case requires you to take a leap to connect dots that were not actually proven. But your duty is to weigh the evidence that has been brought to you and determine if every single element, think identity and intent, were proven beyond a reasonable doubt. The presumption of innocence is huge. It is our liberty. And it remains with my client, remember these two words, unless and until the state removes it with proof of every element beyond a reasonable doubt. That did not happen here. My client remains with that presumption of innocence. The law demands certainty beyond a reasonable doubt. And because the state has not met their burden on identity or on intent, I'm going to ask that you return the only verdict that the law would allow, which is not guilty. And so, I'll go continue.
Okay, Mr. Vernon, you have 7.5 minutes.
May it please his honor.
Yes,
Oh,
you may proceed.
I'm Fred Vernon, and I'll be honest. My true heart's desire is that I could have met you early on during voir dire when the jury was originally impaneled. But we're here now. And the truth is, had I been at voir dire, I would have shared two things. The first thing is that I was born and raised here in Southeast Texas. And my parents raised me with values to work hard, be disciplined, and don't take things that I do not own, that I did not work for. The second thing that I would have shared with you, I would have cautioned you about the tactics of defensive. They're paid to win. And sometimes they take what should be a clear cut, dry face, and they attempt to muddy the waters in an attempt to get you to doubt your instincts, your common sense, and everything that has brought you here to this point in life to help you be successful in your life. They want you to doubt. I'm here to tell you, do not fall for them. That's why I would have cautioned you. But how did they muddy the waters? By giving partial information on the law, not defining terms of the law, and then applying those laws to the facts and breaking it down for everyone to understand. And here, the defense attorney wants you to believe that the defendant did not have intent when he took Ms. Parker's money order and used that money order that did not belong to him, signed it, and paid his energy bill. He paid his energy bill. But notice, the defense didn't define intent for it. Okay? And intent by the law is a conscious desire to take an act to achieve a particular result. A conscious desire is to take an action to achieve a particular result. So here we have an example where the defendant had a desire to take those money orders so that he could pay his energy bill. And that's exactly what he did. You heard it from the defendant's own mouth. I paid my energy bill right there at that window at that market bag. He said that from his own words. Next, when he took the money order, he had some options. Okay, he had some options. The first option, those money orders are not just like cash on the ground, you pick it up, you can't find who it belongs to. He could have got that serial, he would have seen that serial number and said, I'm just gonna tear this up. By the time Ms. Parker got home, she could have phoned Market Basket, and they would have refunded the money right to her account, right? Because it hasn't been cashed. Or he could have read the serial number, knocked on the window to the cashier and said, here, someone dropped these. Someone dropped these. He didn't do that. So the defense said we haven't proved intent. We proved intent. The defendant had options. I would have returned those checks. Most people in here would have returned those checks. Not to say he's a bad guy, but he did a bad thing that day on September 7th, 2021. And we must hold him to account. Next, the defense, again, deploys her tactics. She wants you to believe that because the state provided circumstantial evidence to identify the defendant, that we needed to bring you more. We needed to bring you fingerprints and all this stuff you see on NCIS and all that. Well, the law doesn't work that way. What we did is what the law authorizes us to do. And I asked you to do what the law authorizes you to do. And what she didn't tell you is that the law authorizes you to rely on circumstantial evidence to draw an inference that the defendant is the one that was identified and is the one that in fact took Ms. Parker's property and used it to pay his energy bill. But she didn't tell you that the law allows you to draw an inference of circumstantial evidence in cases to identify the defendant and put him there at that location. Here, you heard from the defendant himself in his own words. No, that's not my dad up there. He's a big guy. He's an old guy. No, that's not the other Dallas Clavell, my brother. That ain't him. I recognize him. Well, who else could it be? And if you remember, my colleague asked him, could it have been you? To which the defendant responded, well, it could have been me. Okay, but we don't have to worry about that. That's a bit of circumstantial evidence. But fortunately, Ms. Parker came and cleared that up for us. She says to you all, she says to this court, I remember him. I remember seeing him there. I remember exactly. I know his family. We live in the same block in Port Arthur, Texas. I know who it was. She didn't doubt it. Okay? She said the only difference between the man she remembers from that day and the man sitting right there was the hair on his head and the hair on his face. It's been 5 years. My hair's changed a little bit. I think I got a little more gray in my hair now, but that's all right. But then we had Detective Poff. He did his investigation, and he saw that the energy bill that was paid by the money orders tied back to a particular location, which tied back to Dallas Clavell, which then tied back to his ID number, his driver's license, his date of birth, his height, his weight, and his race. What more do we need? We have common sense, but the defense would have you not rely on your common sense. She would have you sow discord amongst yourself so you don't have a unanimous verdict for what your instincts, your gut is telling you is the truth. The defense attorney wants you to believe that because the signatures on the bond didn't match with the signatures on the money order, it's not the same person. Ladies and gentlemen of the jury, you sat there and watched the defendant sign this here exemplar, and we know that he signed this here bond. Those don't seem to coordinate. So if we apply the same logic that the defense wants you to apply, because the signatures are not exactly the same between those two documents there, if we apply that same logic, that means that she says because the signature on the money order and this don't match, then that means you can't believe your own eyes because these two didn't match. And we saw him sign it. And the court knows he signed this one. And she said because they don't match, if we follow her logic, this never happened. That's bogus. Again, tactics to dissuade you from using your instincts, your common sense. And
30 seconds.
I'm asking you to find justice. The stolen money order tied to an energy bill, it tied to one person, only one person benefited from the transaction. One person. Dallas Clavell appropriated Mrs. Parker's $437 worth of money orders, intentionally deprived her of her money without her consent.
10 seconds.
You were sworn to be honest, impartial, and do justice, but you were not asked to abandon your common sense at the door. So ladies and gentlemen of the jury, I ask that you find the defendant, Dallas Clavell,
Time is up.
guilty of theft.
Okay, ladies and gentlemen of the jury, we're gonna ask that you would step down from the jury box and you'll follow the bailiff into the jury room. And we will be sending the charge in. Attorneys, y'all come forward. Is back in session. Our court is in session with the announcement docket. What we'll do, we'll wait for the bill to come back in for 1 minute. Court is back in session. Court is in session in two cases. Cause numbers 25 CCCR 1476 and cause number 25 CCCR 1492. Both cases are styled of State of Texas versus Aquila Lee Jamon Hunter. Ms. Jamon Hunter, would you please come forward? Okay, Ms. Jamon Hunter, how are you doing?
Good.
That's good. Now, Mr. Jamon Hunter, you represented in your case by your attorney Giles Cole. And Mr. Cole, how are you doing?
Hey, Judge, how about yourself?
I'm doing fine, thanks for asking. The state is represented in this case by Attorney Farrah Nixon. Ms. Nixon, how are you doing?
I'm fine, Your Honor. How are you?
I'm doing fine, thanks for asking. Now, Mr. Cole, what is your announcement in Ms. Jamon Hunter's case?
We're going to be applying for pretrial diversion, Your Honor.
Okay, I'm going to reset this case. June, second week of June.
June, so June 15th.
Could you, Your Honor, the family's in the middle of moving. I want to confirm, when are you moving?
For June, I have tried for my youngest son,
Where?
in, Judge Stevenson's court.
I mean, they're not the whole month of June, huh?
No, Your Honor.
Okay, this is June 15th, this is the middle of June. Okay, this case will be reset to June 15th, 2026. And at 9 a.m. Ms. Jamon Hunter, you're gonna get your reset from our court coordinator. Once you get your reset, you're free to go.
Yes, sir. Have a nice day.
And same to you.
Excuse Your Honor.
Yes, you may be excused. And we have Mr. Comerford,
His case got reset to, May 15th.
May 15th.
And he said you did not want to have a hearing on this motion.
Okay, next case. We have two cases, cause numbers 26 CCCR 0034 and cause number 26 CCCR 0419. Both cases are styled of State of Texas versus Lakelia J. Bell. Ms. Bell, would you please come forward? Okay, your name is Akeelia J. Bell? Aquila J. Bell?
Yes, sir.
Okay, how are you doing?
No, fine with you.
I'm doing fine, thanks for asking. Now, let's see, your case was reset on March 10th, 2026. To give you time to hire an attorney. Have you hired your attorney?
Today at 3.
Are you meeting with an attorney today at 3? Okay, give us a standard reset.
May 15th?
This case these cases will be reset until May 15th, 2026. Give you an opportunity to hire your attorney. You'll get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. Please have a seat in that chair on the wall. Wait for your name to be called. Yeah, that's fine. Miss Bailiff,
May 15th.
could you move that chair back to the wall? Thank you. Where do we have Mr. Paget? You have resets
Yes, sir.
on all these cases?
Yes, right. Yes, sir.
Well, then, all these people in here, we don't have. Comerford was, let me see, did he talk to? Mario Espinoza?
He's gone.
Okay. Twyla King,
That's supposed to be a dismissal.
that is a dismissal. Okay, I'm just trying to turn it on.
Yeah, because they haven't put it on.
Oh, they haven't?
It's not on here. It's not sent to me.
Okay. Francisco Lozano Alpaz. That's another one of Mr. Patch's cases.
That was just saying.
You have his reset? We can give it to him?
Oh, is it here?
Yeah, he just raised his hand.
Okay, okay, finish this one, judging. He said he was gonna choose people. Why would he want to say? I think that's the one that said he would have. He was gonna have another attorney.
He had another
He
attorney.
said he wants to, yes, and that's why. Who is his attorney? Patty. You want Patty as a attorney?
Oh. You give me the reset, I'm gonna call him up.
Oh, yeah,
Antoine Babino?
that was reset, he had blank for that. He's gone, he's off. What if he probably contact Mike in the office and Mike's probably telling me. Huh? Dale? No. Oh. What's that? This. Okay, it's going to put that, make it clean at 9 AM.
Okay. Latricia Marks. Ms. Marks, your full name is Latricia Monique Marks?
Yes.
How you doing, Ms. Marks? I'm doing fine, thanks for asking. Now, Ms. Marks, your case was reset on March 10th, 2026 to give you an opportunity to hire your own attorney. Have you hired your attorney?
I have one in mind, but I need to talk more with him. That's fine.
Okay, so we're gonna reset your case this last time, to give you an opportunity to talk to the attorney that you want to talk to. All right?
That's fine.
Now, give us a reset. This case is reset to May 15th, 2026. Give you opportunity to hire your attorney. Once you get your reset, you're free to go and you have a blessed day. Please have a seat in that chair on the wall. Jared Wayne Jones, Gerard Wayne Jones, and Jared. Jared.
You put your hat raised.
Okay, let's see, Mr. Jones. Mr. Jones. Hold on a minute. Uh-oh.
What?
Okay, now, Mr. Jones, you first appeared in court, January 12th, 2026. At that time, you stated that you wanted to hire an attorney.
Yes.
And I think you've had another court appearance since then. Have you hired an attorney?
Yeah, I got one, but he couldn't get me in until Thursday.
So you're going to see an attorney on Thursday
Yes,
to
sir.
hire?
That's as soon as I could get in to see him,
Okay,
because he had something going on until then, so.
okay. We're gonna give you your last reset. Give us that date is gonna be May 15th.
Yes.
This is Jared Wayne Jones on page 4. This case will be reset until May 15th, 2026. You'll get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day.
All right, thank you, too.
You're welcome. Just have a seat in the
Yes.
chair on the wall. Timothy Dalton Jennings. I'm doing fine, Mr. Jennings. How are you doing?
Doing well, thank you.
That's good. Mr. Jennings, your case was reset on March 10th, 2026 to give you an opportunity to hire an attorney. Have you hired your attorney?
No, sir. I spoke to Bruce Smith yesterday, so I'm gonna try to get back in.
Okay. Okay. Your case will be reset until May 15th, 2026. Give you an opportunity to hire your attorney. I think you stated his name's Mr. Bruce Smith.
That's what I talked to. I've also did a phone consultation with Charlie Real Officer.
Okay, so whoever you hire, they'll contact the court, but your case is reset till May 15th, 2026. And when you go visit your attorney, you bring your reset with you, so
Bring that paper in.
yes,
Yes.
so they'll know when your case is reset to, once you hire,
Yes.
they may get it, they may have the case reset to another further date,
Yes, sir.
okay?
Okay, thank you very much.
You all can get your reset from our coordinator. Once you get your reset, you're free to go. All right, same to you. You have a blessed day as well.
Oh, you can stay right.
Let's see.
I have Mr. Paget's job.
Okay, I'm looking for the case. Francisco J. Lozano Alpaz. Mr. Question, okay, yeah, okay. Mr. Lozano Alpaz. You are represented by James Paget.
Well, I asked him to like terminate my case because he's not. But I wanted to see if we can get like quarters.
Okay, so you asking him to get off of your case?
Yeah.
Have you hired another attorney? Are you planning on hiring another attorney?
And I asked if I could get a court, one of the ones from the court, if I'm able to afford one right now.
Okay, well, Mr. Paget, you just hold on to that. I'll give it to the court reporter. Mr. Paget has to file a motion to withdraw. Okay, just hold on to that. Mr. Paget has to file a motion to withdraw. And so we'll wait for him to file the motion if he's gonna file a motion to withdraw.
Okay.
Okay, so your case has been reset. In the meantime, you get your reset from court coordinator. Once you get your reset, yes.
Oh, let me ask you, if I'm not able to afford another attorney, can I get one from the courthouse?
You'll come here on your next court date and we'll see, you have to fill out an affidavit of indigence. That's another form that you would have to fill out, okay? Okay, you get your reset. Once you get your reset, you're free to go.
Thank you.
You have a blessed day.
Thank you, thank you.
I sent you the business one too.
Okay, Twyla King. Ms. King, would you please come forward?
First one, that's on here. All right.
Okay, Ms. King, how are you doing? That's good. Now, Ms. King, I have before me a motion to dismiss. Is that correct, State?
That is correct, Your Honor.
Okay, and I'm signing this motion to dismiss that was filed by the state of Texas. You'll be able to get a copy of this motion from our court coordinator, who's sitting to my right. Once you get a copy of this motion, you will be free to go. And you have a blessed day.
You too.
Okay. Yes, you can get your motion to dismiss or the motion in the order. Okay.
You can grab me front while you wait on.
Okay, let me do this here. So we have a question from the, hold on a minute. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M331246. Case of style of state of Texas versus Dallas Clavell Jr. Let the record reflect that the defendant, Mr. Clavell, is present in court with his attorney, Attorney Jennifer DeLage. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon, Attorney Fred Vernon, and Attorney Cornelius Williams. Let the record reflect that the members of the jury is not present in the courtroom. I have received a message from the jury that it has reached a verdict. Will a bailiff please bring the jury into the courtroom? Y'all may be seated. Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present and seated in the courtroom. Foreperson, have you reached a verdict in this case?
Yes, Your Honor, we have.
Is this verdict unanimous? That is one that is agreed upon by all the jurors.
Yes, sir.
Would you please hand the verdict and the charge to the bailiff? Foreperson, is the verdict the unanimous verdict of all members?
Yes, sir.
Okay, you may be seated, Mr. Clavell. Would you please stand with your attorney? We, the jury, find the defendant guilty as charged in the information of theft. Does anyone like the jury polled?
No, Your Honor.
Okay, you may be seated. You have letters. Okay, ladies and gentlemen of the jury, I'd like to thank you for your time and attention to this matter. The trial went a little longer than.
You're fine.
We saw punishment. We did elect the jury chooses punishment.
Oh, y'all did?
Yes, Your Honor.
Yes, Judge.
Oh, I didn't.
It's filed.
Okay. So at this time, ladies and gentlemen of the jury, we need to do how long we're gonna have to do a punch charge. So at this time, we'll be in recess. You can follow the bailiff into the hall.
Respectfully, Your Honor, that they should return to the jury room, Judge, unless they need to take.
Yeah, but we have to draft the charge.
I understand you.
Yeah,
The
so,
trial is still going on, Judge, and they began deliberation.
okay, well, if they wanna sit in the jury room, they can, but it's gonna be hot. Okay. Okay, you can sit in. will the bailiff please, make sure that all the jurors are together and you can bring them into the courtroom? Everyone, well, let's see first.
Oh, yeah, we're getting. Yeah, no, right here. Okay.
Hmm? My pen is not operating. You may be seated. I don't.
You know what?
You didn't send it to me?
Finalized it. It's like it's.
Oh, okay. Where's the first page? Okay. Jefferson County Court, Law number 2 is back in session. The court is in session and calls number M 331-246, case of style of state of Texas versus Dallas Clavell Jr. Let the record reflect that Mr. Clavell is present with his attorney Jennifer DeLage. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Cornelius Williams, and Attorney Fred Burnham. Let the record also reflect that the jury is now present and seated in the courtroom. And Ms. DeLage, I have before me the defendant's election on punishment.
Yes, Your Honor, I'd like to waive my request for the election on punishment to be assessed by the jury.
Okay, so you're gonna withdraw your motion
I would
to
like to withdraw that
the
motion.
election? Okay, so ladies and gentlemen, the jury, the defense has withdrawn its election of punishment by the jury. And so what that means is the court will assess punishment. And state, have you and the defense reached an agreement regarding the punishment?
We have, Your Honor.
And is that correct, Ms. DeLay?
Yes, Your Honor, we have agreed.
Okay, well, everyone, state, would you please come forward, and Mr. Lavelle and your attorney, will y'all come forward?
Yes, Your Honor, thank you. Right here, now.
Where's the punishment page? The form, oh, here it is. Okay, now, state, is there an agreement in this case?
There is, Your Honor.
And what is the agreement?
The essential terms are as follows, Your Honor. It would be 45 days within the Jefferson County Jail. However, that would be probated for a 6-month period of time. There must be restitution in the case in the amount of $437.56 paid to Mrs. Gloria Parker. There would be a letter of apology to Mrs. Parker, Your Honor, as well as 24 hours community service. Is that correct, Mrs. DeLage?
Yes, Your Honor, that is correct.
Okay. It says 45 days. The fine is 0.
That is
that correct?
correct. The fine was
No,
waived
Judge.
in lieu of restitution.
What's the profile?
It's 340. That is what I have, but I don't have an attorney.
That's not part of the code.
Okay, so that's 347.
Okay. Okay, now, 347, court card, let's see, the, community service is 24 hours. I mean, 24 hours community service. Letter. Oh. Restitution. Okay, so this. Yeah, no, I mean, you have this in plain form, so I could just kind of estimate,
Let me get one.
just estimate what it would be.
When were you appointed this thing?
I think it was September,
This year?
no, last year,
This year? Oh,
2025.
No one?
Oh my God.
Mr. Lutz, Mr. Lutz,
Yeah, thank you, Your Honor.
that,
Right, go over it.
yeah.
He's gonna ask him if all this is still true, correct? So this would be true, zero, right? So that's going to be in, lower, so. Okay. You follow? This question is still true.
Two full days. 8 half days.
A lot.
Yeah, so let's see. It's not- Trial perhaps is gonna be 900.
You had to do.
Whoops. Let's do this here.
Anything over, back then, overnight. Thanks one for have this.
Okay.
But years ago, when you sit down, entire, not fixed. What do you think? What you make that.
Okay, here we go. Okay, we're back in session. Now, Mr. Clavell, the state has offered that you serve 45 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 6 months. Now, during the 6 months period, you'll be required to pay, you will not be required to pay a fine because that's waived in the case. You will be required to pay restitution in the amount of $347.
437.
Oh, four, I put three, so it's four. Oh, no, what I did, I was.
You had the 100 and.
Yeah, no,
300, okay.
I was talking about the court costs. You'll be required to pay the court costs of $347. You'll be required to pay a probation fee of $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll be required to pay restitution in the amount of $437.56. You're required to pay now this attorney's fees is $3,150. Total monthly installments is $879 and $880. Are you able to pay that?
No,
All right.
no.
Now you have before you a document that is titled Jefferson County Affidavit of Indigence. Do you recognize that document?
Yes,
And is everything on that document still true and correct?
yes.
Okay, now, let's see. That's 2605. This is. That's, Okay. Okay, now, Mr. Clavell, the court is going to find that you're indigent, and based on the finding of indigency, The attorney's fees in this case will be waived pursuant to Article 46.05 G-11 of the Texas Code of Criminal Procedure. The reimbursement fee of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. The court costs of $347 will be converted to 28 hours of community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. You will be required to to pay the restitution in the amount of $437.56 to the complaining witness, Ms. Parker. The probation fee in this case of $60 a month will be reduced to the statutory minimum of $25 a month. And you'll be required to pay the urinalysis fee of $90. of $15 a month. So instead of paying the balance of $888 or $881, your payments will be $135 a month. Do you understand that?
Yes.
You will also be required to adhere to the other standard terms and conditions of this probation. I mentioned to you earlier, you're required to write a letter of apology to the complaining witness. You're also required to pay back the restitution in the amount of $337.56.
437.
Excuse me, $437.56. Do you understand that?
Yes.
And do you think that this is fair and just?
Yes.
And do you accept it?
I accept.
Okay, so I'll follow the punishment agreement that has been entered into by both parties. Now, Mr. Clavel, you're gonna have a seat because our court coordinator has to draft up
Understand.
the punishment. So once you finish drafting the punishment, you can go, she's gonna call you to the window, and then you'll go to the bailiff and you finish the paperwork and follow the bailiff directions, right? So you can have a seat. All right, and Ms. DeLage,
Thank you.
you're welcome. Ms. DeLage, you are, if you want to stay around, you're free to go.
Thank you, Your Honor.
And you have a blessed day. Now, ladies and gentlemen of the jury, this will conclude your jury service. First of all, I'd like to thank you for your time and attention that you have given to this case. It was good having you in court with us these last 5 days. Okay. Now, I must say that this might be a record.
I'm all about making records.
I think this is for county court at law number 2. Since I've been here, I think this is a record. We haven't been in trial 5 days, not that I can remember. Matter of fact, the court coordinator, what did you call it? A misdemeanor?
A capital misdemeanor.
Like a it was like a capital misdemeanor. So yeah, again, thank you for being here today. Make sure that you return your badges. The court bailiff, she has some letters that she would like to give each and every one of you. If you'd like to drop us a line, you can. I know that earlier, I think Monday, when the other panel members who did not make the jury, I mentioned to them that anytime that they're in the area of county court at law number 2, they can come and have a seat in that area. And we call that the peanut gallery. And you can come and have a seat in that area too. But you can't bring peanuts in here and eat because this is not the Texas Roadhouse. So you can come and have a seat in your courtroom and see what goes on in Jefferson County, Texas. And I know by sitting on this one case, you realize that we have some very interesting cases that come before this court. Now, also, as I mentioned to the other jury, I usually give handshakes, but we still have COVID in our community. But at this time, I like to give everyone what I call an air handshake. Okay, so thank you for your time and attention. Our bailiff, I think she's going to the back to get some letters. Once she gets those letters, she'll give each and every one of you a letter. You'll be free to go. If you need a letter, do they get that from the district clerk's office? And the district clerk's office is right across the hall. And you will be compensated for all 5 days that you've been here. Okay? So again, thank you. Oh, I forgot to mention. The attorneys might want to talk to you once you leave the courtroom. You can talk to them if you want to. If you don't want to talk to them, you don't have to talk to them. Okay? So I just want to let you know that. So again, thank you for being here. These last 5 days, it was good having each and every one of you here. And once you leave, we're gonna ask that God, you say have God's speed, but everyone, please have a blessed day. All right. If you have any questions of me, you can ask. If not, once you excuse, you're free to go. Okay, you're welcome. Oh, she already gave y'all a letter? Oh, man, that was fast.
That's movie. She's so fast, you don't see her.
Okay. All right. Y'all free to go and y'all have a blessed day.
Thank you. Thank you.
Thank you.
Thank y'all.
Thank you. Thank y'all. Thank you for your time. That was one thing you have to.
And let me do this here. Have him to come back up.
Oh, I was gonna step out. now.
Okay, no, y'all want y'all to come back up.
Okay.
I just have before me the trial court certification of defendant's right of appeal. Now, I see that y'all checked off 2 boxes. You probably just need to check off 1 because this case was not, well, it's a plea bargain to the punishment.
Wait, I just.
We could
did
write
it.
that 2 punishment, right?
Yeah,
That's what I was thinking.
2 punishment, you want me to write that?
yeah.
4 yeah.
Oh, you got a pen?
Yeah.
Oh, you're gonna let me touch your pen?
Oh,
Your
Bare-handed.
wife gonna get on you.
oh, yeah.
It's
She's
a nice
nurse.
pen.
What is this? Why do I have,
I guess I could put my.
why do I have this here?
Just use this one.
What? What, they didn't have to sign. Oh, yeah, you didn't have to sign this here.
You go, Your Honor.
So.
Okay, and the only thing they
You
need
want
is,
that back?
yes. Now, let me do this here, Mr. Clavel. I have before me a document that's titled Trial Court Certification of Defendant's Right of Appeal. And do you recognize this document?
Yes,
And is this your signature on the line? It's titled defendant.
yes.
Now, before you sign this document, did your attorney go over this document with you?
Yes.
And this document states, in box number 1, it's a plea bargain case. The defendant has no right of appeal to the plea to punishment on it, and the defendant has waived the right to an appeal. Is that correct?
Yes.
Okay, and
Copy of.
Hmm?
Get a copy of that.
that was,
They're gonna
it's gonna
get
be in your
Oh,
file.
okay.
It's gonna be in your file. So, this here will go in his file.
Okay.
All right. And this here will go in his file as well, the misdemeanor plea form. Okay. All right, that's it.
Thank you, Your Honor.
And y'all
Having
have a
done
blessed day.
further business before this honorable court, may the state be excused.
Y'all excused.
Thank you.
Okay, y'all have a blessed day. Thank you. You welcome.
Have a seat, man, kids.
Okay.
Good luck to you, Mr. Coombs.
Okay. And this will conclude the calling of the case. Cause number 2, M331246, case of Style Sex Texas versus Dallas Clavell Jr. Everyone, please have a blessed day.
Have a good weekend.